My name is David Cole. I'm a professor at Georgetown Law School, longtime supporter of the American Constitution Society. The disclosures about the NSA's surveillance programs in the last couple of weeks, I think, are stunning and I think raise really serious questions both about our governance and about our privacy. They're stunning because I don't think before The Guardian broke the story that anybody thought that the Patriot Act authorized the government to pick up phone data every time any American picks up the phone to call anywhere. If they're calling their mother from school, if they're calling their grocer, if they're calling their doctor, if they're calling their psychiatrist, all of that is automatically delivered to the National Security Agency without any individualized suspicion that anyone's involved in any kind of terrorism. That is a stunning revelation. And I think had we known that that was the scope of the surveillance that the Patriot Act amendments were authorizing, there would have been much greater opposition to those amendments, and I think they would have been crafted more narrowly. So I think it raises really two issues. One is an issue of governance. We should not be, in a democracy like ours, subject to secret laws and secret programs that we don't have an opportunity to weigh in on. It may be that when we learn the full scope of the programs that the NSA is conducting, that we would decide, you know, it's worth it. The risk, the trade-offs are worth it. But we have to make that decision, and we can't make that decision if it's adopted in secret and in a way that nobody in the general public would have any conception was being pursued. And then the second concern is the concern just about our privacy. And you know, some people say, well, if you've got nothing to hide, why are you concerned about the fact that the NSA can get your phone calling data and in certain circumstances can get your email traffic, your internet browsing, and the like? Well, I think there's a great deal of reason to be concerned. I mean, we've seen in the past that these kinds of tools, while adopted in the name of fighting national security, inevitably get used more broadly and abused to target people who the administration finds to be inconvenient or a dissenter or an enemy, as President Nixon labeled them. So, you know, COINTELPRO, the FBI's program, was initially an anti-communist program and ultimately involved spying on people in the civil rights movement, the anti-war movement, the women's movements, and the environmental movements. We don't want our government to be engaged in that kind of practice, and the best way to ensure that it isn't is to ensure that it has strict limits on its surveillance powers. It's certainly better to have a court, an Article III court staffed with Article III judges, to ensure that the administration is indeed following the law in its tactics. And I think the fact that the court exists is a check in and of itself. Even if it ultimately, in almost all instances, says yes, many people who have been involved with the program on the inside, both on the side of the court and the side of the government, have said the fact that the government has to go to a court means that they are more careful, much more careful, than they would be if it was entirely internal executive decision. However, I think it's far too secret. I think, you know, certainly ongoing operations, there's a need for secrecy, but the interpretations that the court has given to the statutes that we think are constraining the government, we ought to know what those interpretations are. I mean, for example, Section 215, which was the authority used to get all of our phone records, it says that the government can get business records where they are relevant to an investigation into countering international terrorism. Now, nobody thought that that language could somehow be read to give the government carte blanche to get every American's phone data every time they pick up the phone, and yet that presumably is what the courts have found. We ought to know that so that we can correct it if we conclude that's too broad. We're willing to give the government surveillance powers, but they've got to be more narrowly tailored than that.